Hey everybody, welcome back to the Court of Random Opinion. My name is Neidigh. I have another quick update for you. Leslie Sloane and Vision PR have filed a motion to dismiss Justin Baldoni and the Wayfarer Parties' amended complaint. Now, first we're going to take a look at that motion to dismiss document, and then we'll go over the reasoning for it. Somebody says, or is his team trying to dismiss her nothing burger? So I expect that they will also file a motion to dismiss. But however, this is specifically Leslie Sloane and Vision PRs, and they're going to explain why they think that it should be dismissed. And they have also asked to, exclude, I think, Exhibit A, which was Justin's whole timeline with the evidence. Yes, they're moving to strike Exhibit A to the amended complaint. All right, let's see. I've got it up here for you guys. Thanks, everybody, for joining. I appreciate it. All right, hopefully everybody can read that. Don't worry, it won't be too long. It won't be too long. I know the other night was a 5-hour stream when we went over that initial complaint. However, this is a very short document, and then the next document we have is only like 30 pages or something, 20 pages. All right. Notice of Vision PR Incorporated and Leslie Sloane's motion to dismiss the amended complaint for attorney's fees and costs, and to strike Exhibit A. Please take notice that for the reasons stated in the memorandum of law submitted herewith, Leslie Sloane and Vision PR Incorporated, by and through their attorneys. Look, man, I can't say that name. Boyce Schiller Flexner. Oh, that's not that bad. Okay, my bad. Hereby move this court before the honorable judge. Let's see. For an order 1, dismissing the claims against them with prejudice pursuant to Federal Rule of Civil Procedure 12b-6. 2, awarding them attorney's fees and costs under New York's anti-SLAPP law. And 3, striking Exhibit A to the amended complaint pursuant to Federal Rule of Civil Procedure 12f, dated February 12th, or 20th. Sorry, that's today. And then here we have, like I said, this is only 33 pages. This is their memorandum of law in support of their motion to dismiss the amended complaint for attorney's fees and costs and to strike Exhibit A. We've got a whole table of contents here. Let's just scan through this really quickly. 1, the amended complaint must be dismissed due to impermissible group pleading. 2, the amended complaint fails to state a claim for extortion, fails to state a claim for defamation. Ms. Sloane's alleged statements do not concern 6 of the 7 Wayfarer parties. Ms. Sloane's alleged statements are in actionable opinion, or, in the alternative, are substantially true. Ms. Sloane's alleged statements are in actionable opinion. Okay, again. The alleged statements concerning sexual assault are insufficiently specific. The Wayfarer parties fail to allege actual malice. They fail to allege actual or special damage. The amended complaint fails to state a claim for false light. Okay. Ms. Sloane and Vision PR are entitled to attorney's fees and costs, and the court should strike Exhibit A to the amended complaint. Now, Exhibit A, like I just said, was that whole evidence timeline of Justin Baldoni's. Now, if you were on my stream, I think it was yesterday morning, I lost all sense of time after reading that initial amended complaint. But here, just really quickly, I'm going to show you. This is courtlistener.com, and if you missed that, you can go back and watch yesterday's video. It's only 6 minutes long regarding the subpoenas and all that. And it'll show you how to access courtlistener.com and to get the same alerts that I do, so that when things hit the docket pretty much right away, you can get them yourselves and read over them yourselves. So this was the Exhibit A. The following timeline is intended to be read in conjunction with consolidated plaintiff's first amended complaint and is expressly incorporated therein by reference. This document provides a summarized account of the sequence of key events. Okay, and we went over all that as soon as the amended complaint came out. So obviously we're not going to look at that. Again, I don't have another 6 hours in me, but all right, 1 second. Let's hop back over to this document. Okay. Snow Wonder says, Lauren, the hardest working person when it comes to keeping up with this. Hey, man, like I said, I just get these alerts the same way that you guys can. So, I mean, I just get over here as quick as I can. It helps that I mostly work from home. So, yeah, I just I try to stay ready to come up with whatever. All right. Table of authorities. We're not going to go through that. And I'm sure my friend Omar, who came on that stream with us to go over the amended complaint, is going to go through some of this legal stuff, but I'm not going to go through the table of contents right there. Okay. Also want to remind you guys, I am not a lawyer. That's why it's called the court of random opinion. I'm just a random person. This is mostly conversational, and I work in mental health, so occasionally I can give those perspectives. But it's Leslie Sloane and Vision PR who are seeking to dismiss, also to strike Exhibit A, and also to get attorney's fees and costs. So I also want to remind everyone I am not a professional content creator, so please be gentle with me. I do the best I can. All right. Consolidated defendants Leslie Sloane and Vision PR respectfully submit this memorandum of law in support of their motion to dismiss the amended complaint for failure to state a claim for attorney's fees and costs, and to strike Exhibit A of the amended complaint pursuant to Federal Rule of Civil Procedure 12B6 and F and New York's anti-SLAPP law. Preliminary statement. Justin Baldoni has spent years profiting off the feminist and Me Too movements. God, guys. I mean, it's a little afternoon, but it's still too early to be such a cunt. All right. Peddling books, podcasts, TED Talks, and more using slogans about believing survivors, ending victim blaming, and promoting informed consent. His conduct in this dispute is therefore sheer hypocrisy, beginning with his egregious sexual harassment of multiple employees. Wow. And continuing with his ongoing campaign to discredit and blame his victims and punish anyone who speaks out against him. So the stuff that they're using against him, like the TED Talks and stuff like that, that was what, like almost 10 years ago? What, like 8 years ago? 7 years? I don't know. And it's really gross that they're using that to kind of manipulate. And like, I do feel like people are very aware that this is very much like under public scrutiny right now. So I feel like they know that it's kind of gross to use it this way, but they know also that there are a lot of people out there, especially, since the Me Too movement, who will, be kind of gripped by this strategy of, painting him out to be some sort of disgusting abuser or harasser or whatever. And they're using his own, like, kind of not movement. They're using his own work to do it. And it's interesting because, number one, I feel like it really does only paint him out to be kind of a good guy. Whether or not and we talked about this in this morning's video, whether or not you think that it's cringy for him to be like a male feminist or whatever, or whether or not you think it's cringy for him to do the TED Talk. And I don't think that he's a cringy person in general. Whether or not you think that, it's like, they're just kind of like targeting your feels right now. So like, you can kind of see that, right? Like, if you really think about it, I mean, what other purpose would that serve? It's like, it's making him look like a good guy pretty much. And then they're also using it to try to flip the script and be like, hey, look at this slimy motherfucker over here. I mean, I don't know. They probably didn't write it like that in this motion, but in my opinion, they should have, because it would be, a faster way to just say, hey, I'm being kind of a cunt. Like I just said. Somebody said, I'm a lawyer. Oh, let me get this lawyer's comment. Oh, there's two attorneys in here at least. Well, here's one. Anna Fan. I'm an attorney. This motion will not get granted. Motion to dismiss is very hard to get granted. Thank you, Anna, for chiming in. I appreciate you. All right. And then somebody says cringy is not equal to evil. Absolutely not. I mean, I'm cringy sometimes. I'm not evil. I mean, well, I mean, early in the morning maybe, but Anyways, this is not what you came here to listen to. So let's get back into it. The Wayfarer Parties allegations about Blake Lively boil down to she was too ambitious. Okay, keep reading. Okay. Too outspoken, and she should have accepted Baldoni's bizarre and abusive practices without complaint, no matter how uncomfortable they made her and other women on set. It's very hard not to stop myself after every couple words and be like, hey, by the way, that's bullshit. But okay. How far into the stream are we? It took me less than 10 minutes, I promise, to get demonetized today. All right. Anyways. As alleged in Ms. Lively's complaint, Baldoni invaded her trailer while she was undressed, improvised kissing scenes without her consent. Okay, no. And repeatedly crossed professional boundaries by showing her a video of a naked woman. Again, we saw in the exhibits in Justin's timeline, the woman was not naked, but okay. Discussing his pornography addiction and discussing his past sex life, including instances when he did not always listen when women said no. Unfortunately, Ms. Lively was not Baldoni's only victim. Once again, I'm not seeing anything to prove that, but all right. Baldoni does not deny the lion's share of misconduct for which he is accused. What? Instead, he tries to contextualize his behavior and suggest that Ms. Lively asked for it. And the footnotes down here, hang on. We have initially capitalized terms not defined herein shall have the same. Okay. Footnote number 2 says, for instance, Baldoni responds to Ms. Lively's allegation that Baldoni and Heath invaded her trailer uninvited while she was undressed, including when she was breastfeeding her infant child, by publishing a text message where Ms. Lively invited Baldoni to her trailer. Dude, she did invite them to her trailer. What do you mean? What do you mean? This is crazy. All right. Can I kick it? Yes, this just hit the docket. This is Leslie Sloane and Vision PR's motion. All right. When Ms. Lively bravely spoke up about Baldoni's predatory behavior, he and his team used every weapon in their arsenal to blame, embarrass, and silence her, going so far as to hire a crisis PR manager who promised to bury Ms. Lively and destroy her life. Once again, I'm going to say this. Hiring a crisis PR manager, that's not a crime either, obviously. Otherwise, they would be like black market PR firms. Like, what? Okay, that's ridiculous. And once again, I'm going to echo the sentiment. Why hire someone to destroy someone's life or to bury them if that person is already being such a magnificent idiot in the first place? So you can hire a crisis PR manager just to make sure your own image isn't getting, like, mud slung at it, and you're doing the best you can to come out of it alive. I don't think that this means necessarily what they're saying it means. I can't for sure 100% say that it doesn't, because we have to watch this play out in court. But no, I'm just, God, I feel like when you read these complaints, I feel like it's just really the way they're kind of manipulating the words, and the way they're manipulating the things that happened, especially in his past that has nothing to do with her whatsoever. I don't know. I feel like this whole thing is just like one big, and I hate that this word is so overused, but I do feel like it's a lot of gaslighting. I don't know. All right. Baldoni also trivializes the dispute about sexual harassment and retaliation by trying to recharacterize it as a mere battle for creative control of the movie It Ends With Us. Baldoni's allegations about the creative issues are irrelevant and tellingly sexist. Okay. First, we're going to blast the man for being too feminist, and now he's sexist. All right. Okay. Because Ms. Lively, an executive producer on the film, dared to offer input on the script, wardrobe, and editing, Baldoni blasts her as tyrannical and aggressive, among other coded terms. The Wayfarer Parties dragged Leslie Sloane and Vision PR Inc. into the instant litigation as a smoke and mirrors exercise to distract from their own sexual harassment and systematic retaliation. But the Wayfarer Parties never had a Rule 11 basis for accusing Ms. Sloane or her company of propagating malicious stories or a smear campaign about the Wayfarer Parties. Other than one New York Times article that they cannot plausibly connect to Ms. Sloane or her company in any way, the Wayfarer Parties do not identify a single malicious story that is part of their invented smear campaign. I mean, pot me kettle, I guess. By the Wayfarer Party's own allegations, all Ms. Sloane did was respond to a press inquiry about a story that Baldoni's team seemingly planted. The amended complaint does not and cannot identify anything Ms. Sloane did that comes anywhere close to the damning communications between Baldoni and his own publicist concerning an explicit campaign to destroy and bury the woman employee who accused him of sexual harassment. Okay. I feel like they're really writing this accused him of sexual harassment thing out as like a badge of honor or something now. And no. Pandora Facts, thank you for the $2. Are victims and not perpetrators because they are female? That kind of sounds like that's what their view of this is, right? Anna Fan, thank you for the $10. You were so funny every time you say the C word. Well, Anna, thank you for the $10. You are, in fact, not a cunt. Appreciate it. All right. There was a footnote down here. We continued from the one up there. So it was like invited her to the trailer to rehearse while pumping breast milk. Okay. And then it said also, but as Baldoni has preached, consent is specific and reversible. Oh, God. I got to find a new word. These people are exhausting my cunt. All right. So they're like legit linking to old stuff from his Instagram now. Let's take a look at what this is. Hang on.
French fries and consent have in common?
If we were gonna go get fries, I'd be like, hey Liz, are you hungry? Does that sound good to you?
That sounds great. I would love that.
So we go to the store and I go and order fries. And while I go to get the fries, I come back and what if you don't want fries anymore? What if you just change your mind? You saw something else on the menu. Is it okay if I just like make you eat the fries?
No, I don't think
that's
anyone.
Not okay.
No, that's never okay.
That'd be a bad look, right?
That'd be a bad look.
So first of all, you say, no, I don't want fries anymore. I don't make you eat the fries. Then another situation could be we start eating the fries. But after a few bites, you're like, I don't want the fries anymore. I don't just like start shoving them in your mouth and make you eat the fries, right?
Or yell at me.
Unless it's like lunchtime. All right. So we get the point there. And it's just weird that they're putting that in this context. Chris Wickham, how much is Justin paying you? Dude, you guys are getting paid for this? Like, where do I sign up for that? Jesus Christ. I know people are saying don't feed the troll. However, the troll is feeding my algorithm. So, go off, King, I guess. I don't know what you thought you accomplished with that because it really just didn't hurt my feelings. All it did was, I guess, make me feel a little bit left out of the, payroll. But all right. Okay. So they're using that clip to show that he has preached that consent is specific and reversible. So rather than just being, straightforward and saying that, hey, like, even if this happened, the case is that consent can be, reversed or whatever, they're just, using his own social media and stuff like that to be, a special kind of asshole. And an invitation to enter Miss Lively's trailer on one occasion is not an open invitation to enter her trailer whenever he pleased. Further, a true advocate for postpartum mothers would know there is a radical difference between pumping and breastfeeding. Ms. Lively's text message does not undermine her credible allegations in the least. In his TED Talk, Baldoni presciently asks, are you confident enough to listen to the women in your life and hear their ideas and their solutions, to hold their anguish and actually believe them even if what they're saying is against you? See, and then there's another tiny URL. I'm afraid to click on this because they're being so sensational in this. Okay, so he is the whole, they have the whole why I'm done trying to be man enough TED Talk there, which I'm actually going to watch later. I've never seen it before, so yeah. Hey, Crow, what's going on? All right. You just close out these really quick. Oh, well, that's what I was looking at, by the way. I didn't play any of it, though, so you didn't miss anything. All right. At 13:30. I guess we could pull up that specific clip. Bear with me, guys. I'm sorry about that. 13:30. Oh my God.
Another man when you be sensitive, be, even if it makes you look weak. Are you confident enough to listen to the women in your life, to hear their ideas and their solutions, to hold their anguish and actually believe them, even if what they're saying is against you? And will you be man enough to stand up to other men when you hear locker room talk?
I won't go over the whole thing, obviously, while we're going through this document, but I don't know. It just kind of seems icky to me to, use his own words against him. Whether or not you're like a diehard feminist, I feel like you viewing that and then, like seeing the way they're treating this man, it does not make me feel like I'm going to align more with things that are in their favor at all whatsoever. It just makes me feel like, wow, you guys really are just a bunch of jerks. And I know the lawyers, obviously, they're doing their job, but it's what it seems like to me. So it's just, I don't feel like it's a really good strategy at this point anymore. When I first started reading the amended complaint where they were doing this, I was like, oh, I guess, for their purpose, their lawyers are doing a good job. However, it's become kind of obsessive to the point where they're now just like directing people to clips where he looks overwhelmingly good, in my opinion. So it's not accomplishing what I thought it would accomplish. I could see like a little tiny bit if they had played on that a little tiny bit, just enough to kind of spark questions in the mind of the reader. That might have been good. But this harping on it is just, it's not doing what they're trying to do, I don't think. Well, not at least, I mean, to the public, you know what I mean? Like I said, this is a court of random opinion. I'm not the judge. I can't say what the judge is going to think. But to the public and to me, at least some of us are going to see that and think like, wow, what a terrible strategy. So, yeah. Okay. The amended complaint does not and cannot identify anything Ms. Sloane did that comes anywhere close to. We start at the top of this page, my bad. Okay, we did that. Okay, yeah. The Wayfarer Parties accuse Ms. Sloane and Vision PR Incorporated of extortion, but do not and cannot identify where or how the alleged extortion occurred, or how Ms. Sloane or Vision PR Incorporated received anything of value because of that extortion. They also assert claims for defamation without complying with the basic requirement of identifying or describing the statements they allege are defamatory. Because the amended complaint's scattershot allegations fail to adequately plead claims for civil extortion, defamation, and false light, Ms. Sloane and Vision PR Incorporated respectfully request that the court dismiss the amended complaint with prejudice and award attorneys' fees and costs under New York's anti-SLAPP law. Okay. Factual background. Ms. Sloane is the owner of Vision PR Incorporated and the renowned longtime publicist of numerous celebrities, including Ms. Lively and Ryan Reynolds. She has a decades-long reputation for professionalism and trustworthiness, and the Wayfarer Party's baseless claims against her have caused her irreparable professional damage and emotional harm. Ms. Sloane has never leaked sensitive stories to provoke public controversy on behalf of any of her clients, and the Wayfarer Party's attempt to characterize Vision PR Incorporated as a Harvey Weinstein-backed PR firm is intentionally misleading. Vision PR is entirely unaffiliated with Weinstein, and any stories that the Wayfarer Parties have planted or encouraged claiming that Ms. Sloane ever worked with Weinstein to attack or discredit his victims are baseless. I'm going to be honest with you guys. I've spent so many hours going over the documents and streams that I don't actually recall them being called a Harvey Weinstein-backed PR firm or anything like that. I'm not saying it didn't happen. I'm just saying it doesn't stick out of my mind. So I'll take a look into that later, and then maybe we can talk more about that. All right. The Wayfarer Parties claim that Ms. Sloane initiated the public relations war between the parties and orchestrated a smear campaign against Baldoni, but the amended complaint does not allege any facts to support these inflammatory accusations. Okay. And then the footnote here at 4 says, this allegation is meant solely to harm Ms. Sloane and inflame the reader. Well, that's, once again, kind of pot, meat, kettle, but okay. All right. Their own submissions, in fact, prove the opposite. Baldoni's PR team began plotting against Ms. Lively as of at least July 31st, 2024, and by August 4th, his publicist Jennifer Abel wrote that she wanted to plant pieces this week of how horrible Blake is to work with. Huh. Melissa Nathan, who Baldoni hired as a crisis management expert on the promise that she can bury anyone, responded that she had already off the record spoke to the editor of the Daily Mail. Ms. Sloane, by contrast, is not alleged to have spoken to the press until 4 days later on August 8th, when she responded to a Daily Mail reporter's inquiry. In other words, by the amended complaint's own allegations, Ms. Sloane did not speak to the press about Baldoni until August 8th, when she responded to a press inquiry about a story that Baldoni's team planted days, if not weeks, earlier. Okay. So this is like all looking at specific stuff in the amended complaint. And I don't know if anybody really wants me to waste too much time going back and forth there. So we're going to move on. But let's see. I do recall some of that stuff that they were talking about. Okay. The Wayfarer Party's claims against Ms. Sloane and Vision PR Incorporated appear to arise out of the statements that Ms. Sloane allegedly made to the Daily Mail reporter that she spoke to on August 8th. According to the amended complaint, the reporter asked to speak with Ms. Sloane regarding problems on the set involving Blake Lively and Justin Baldoni, and the fallout over that with Blake being labeled difficult and a power struggle existing. And Miss Sloane responded, "That is 1000% untrue, and your info is totally off." Miss Sloane further stated, "The whole cast doesn't like Justin, nothing to do with Blake. And I'm telling you, she's a liar. They are panicking as the whole cast hates him." Okay. Maybe we should take a look at that, guys. Give me one sec. I've already got it pulled up here. So we're going to 190. Oh, no, not the exhibits. My bad. Give me one sec. Okay. All right. So here's what 190 said. In fact, Sloane actively continued her discussions with the Daily Mail reporter, citing false information to cast Baldoni in a negative light. To divert attention from Lively's tyrannical behavior on set, Sloane attempted to portray Baldoni as the antagonist, stating, "The whole cast doesn't like Justin, nothing to do with Blake," right? She doubled down, insisting, "I'm telling you she's a liar. They're panicking as the whole cast hates him." Sloane also threatened the reporter, saying, "The entire case I will have go on the record. This needs to hold." And then here you can see the text from Leslie Sloane to the Daily Mail reporter. It says, okay, "There's clearly something going on because it's cold from 3 reporters and none of them are me. I'm just the only one not afraid to reach out to you, LOL." She says, "You have it all wrong. Your reporters are so wrong." Daily Mail reporter says, "Okay, I'm just being straight up with you because that's how I roll always. I'm coming to you because I actually like Blake and don't want Daily Mail to fuck with her." One of them said that Blake and Ryan insisted on rewriting the movie, and another that she got very opinionated over directorial issues. "Do you want to ring me when you land, and I'll tell them that they need to hold off on anything for a few because her rep is unavailable and need to at least get no comment. No one knows that we speak, just that you would read emails from me and respond." And then Sloane says, "Yes, please, as this info is all wrong. She didn't require script runs, nothing to do with this. She produced the film and got a cut." I think got a cut is what she meant. "WTF is going on? The whole cast doesn't like Justin, nothing to do with Blake." And I believe that in this amended complaint, they said that Leslie Sloane had agreed that they were not going to talk to reporters. And that's when this happened. But correct me, please, if I'm wrong in the comments, because I'm not going to go through the entire amended complaint again right now. Okay. In other words, by the amended complaint's own allegations, Ms. Sloane did not speak to the press about Baldoni until August 8th, when she responded to a press inquiry about a story that Baldoni's team planted days, if not weeks earlier. Okay. We read that, didn't we? According to the amended complaint, the reporter asked to speak with Ms. Sloane. And Ms. Sloane responded, "That's 1000% untrue. Your info is all off." Okay. The amended complaint also includes a screenshot of text messages between Nathan and the reporter, which were purportedly exchanged following the release of Lively's administrative complaint on December 20th. In the text, the reporter writes, "She said the whole cast hates Justin. This has nothing to do with Blake, and now she's saying that Blake was sexually assaulted. Why wouldn't she say anything about it then?" Ms. Sloane did not write the words appearing in these messages, and the amended complaint does not allege otherwise. Okay. Despite including multiple screenshots of text messages written by Ms. Sloane, the amended complaint includes no messages where Ms. Sloane writes that Blake was sexually assaulted or uses similar language. While the amended complaint fails to provide the requisite context for any statements allegedly attributable to Ms. Sloane, the only plausible reading of this conversation, which did not include Ms. Sloane, is that the reporter read the December 20th administrative complaint and was himself characterizing those allegations as Ms. Lively being sexually assaulted. Where was there really I guess if they're going to make allegations of sexual assault, they would be referring to what the alleged improvised kissing, which I don't know about that, but okay. Legal standard. To survive a Rule 12b motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Legal conclusions are not entitled to any assumption of truth, nor are more recitals of the elements of a cause of action. When the claims in a complaint have not crossed the line from conceivable to plausible, the complaint must be dismissed. what makes something plausible? Would it be possibly be providing evidence, like such as the text message you allege to have and the complaints you allege to have and stuff like that? Because if you want to talk about that, we can get into that. Can I Kick It says, so basically Sloane could have a lot of fault here if found to have started first. Okay. And if any of our lawyer friends in the chat want to chime in, please go ahead. Hi, everyone joining from New Zealand, Australia, everywhere else. That's pretty cool. All right, let's keep going. Argument. The Wayfarer Parties assert claims for extortion, defamation, and false light invasion of privacy against Ms. Sloane and Vision PR. Each fails for multiple independent reasons. 1. The amended complaint must be dismissed due to impermissible group pleading. As a threshold matter, the amended complaint should be dismissed because it's replete with impermissible group pleading and that it generally attributes misconduct to the defendants collectively while failing to differentiate between the multiple defendants. There's a footnote here for argument. It says, Ms. Sloane and Vision PR incorporate by reference arguments made by Ms. Lively, Mr. Reynolds, and the New York Times Company to the extent applicable here. Okay. Each cause of action is asserted by the Wayfarer Parties collectively against the Lively Parties collectively. For example, the defamation claim is asserted against all 5 Lively parties, but does not identify the defamatory statements, much less which Lively party said them. Okay. Ms. Sloane cannot be held liable for defamation for statements made by Ms. Lively or Mr. Reynolds, and vice versa, nor can she be held liable for an allegedly defamatory article published by the New York Times, where she did not even serve as a source. The amended complaint also lacks a basic mapping of which Wayfarer party, as a plaintiff, is asserting claims against each of the Lively parties. An explanation for the basis of each party's claims is required here, as it cannot be that each plaintiff has good faith claims against each defendant. For instance, there is no viable defamation claim that the Wayfarer parties can assert Ms. Sloane because Ms. Sloane is not alleged to have made a single statement, let alone a defamatory statement regarding anyone other than Baldoni. Similarly, the Wayfarer parties cannot assert an extortion claim against each of the Lively parties when Ms. Sloane is not alleged to have received anything of value for any of the Wayfarer parties, and she did not communicate with anyone other than Nathan. The amended complaint must therefore be dismissed. And there's a footnote 6. In any event, any statements concerning Ms. Lively's complaint, including but not limited to the New York Times article, are privileged under New York civil rights law. Okay. The amended complaint, this is number 2, the amended complaint fails to state a claim for civil extortion. The civil extortion claim fails for several reasons. First, civil extortion is not a cognizable claim under New York law, which clearly applies to the claims against Ms. Sloane and Vision PR. And guys, the reason I'm not going through these specific cases that they're citing here is because, like I said, I'm not a lawyer. I do know there are a lot of great law tubers out there who are going to cover this, and also my friend Omar, the lawyer, is going to be going over this, I'm sure. Okay. Without any analysis whatsoever, the Wayfarer parties assert their claims under California law merely because Lively has contended that California law applies as to her own affirmative claims. That's in the AC at 211. Let's look at that really quick. Okay, so here's what they said in 211. It says, already pushed to the brink, Abel finally had enough when Jones demanded she corroborate falsified accusations about a senior Jones employee in an effort to drive him out. When Abel refused to go along with it, Jones responded with mockery, calling her a 12-year-old drama queen. So what does that have to do with anything? Her own affirmative claims, AC at 211. Huh. Was that a miscitation, or did I get that wrong? Anyways, we're going to move on. All right. Ms. Sloane and Vision PR Incorporated do not stipulate to the application of California law as to the claims leveled against them, however, and to determine what law applies. New York courts conduct an interest analysis and apply the law of the state having the greatest interest in the litigation. Here, New York has the greatest interest in the dispute. The Lively parties are all domiciled in New York. and the Wayfarer parties concede that all relevant conduct occurred in New York, and that they allegedly suffered harm within New York. Accordingly, New York law applies. Okay. Second, even if New York were to recognize a civil cause of action for extortion, it must be dismissed as impermissibly duplicative of the defamation claim. The Wayfarer parties do not allege that Ms. Sloane engaged in any wrongful conduct beyond making a handful of statements that the Wayfarer parties claim are defamatory. Their claim therefore sounds in defamation, and the Wayfarer parties... Okay, hang on. Their claim therefore sounds in defamation, and the Wayfarer parties may not circumvent defamation defenses by styling their claim as some alternative tort. Third, the extortion claim fails regardless of whether the issue is controlled by the law of California or New York, because there are federal courts in California which indicate that no such cause of action is available under California law, and the California Supreme Court has not yet determined the issue. Fourth, even if the court were to determine that California law applies and follow decisions recognizing a claim for civil extortion under California law, the Wayfarer parties fail to allege the essential elements of that claim. Extortion refers to 1, the obtaining of property from another with his consent, 2, induced by wrongful use of force or fear or under color of official right. Okay. Because extortion is in substance a fraud claim, it is subject to the heightened pleading requirements of Federal Rule of Civil Procedure Rule 9b. Okay. So Intermarketing Media LLC v. Barlow said, to satisfy this standard, plaintiffs must allege the who, what, when, where, and how of the misconduct charged. Here, neither element of an extortion claim is alleged, much less with particularity. The Wayfarer parties do not and cannot allege that Ms. Sloane or Vision PR Incorporated obtained any property from them. Okay. Okay, let's see. Even assuming for the sake of the argument that the civil cause of action for extortion exists, plaintiff's complaint fails because it does not allege that defendant actually obtained property from her. And that was DeSelms. Okay. Like I said, I'm not going to get too much into the legal stuff, guys, because I'm reading that and I'm like, I definitely want to hear from somebody who knows what they're talking about as far as the specific cases goes. All right. Nor do the Wayfarer parties allege that Ms. Sloane used force or threats to obtain anything from them. In fact, the amended complaint does not allege that Ms. Sloane so much as spoke to 6 of the 7 Wayfarer parties. And in her limited communications with Nathan, Ms. Sloane is not alleged to have said anything improper, let alone threatening. Okay. 188 and 191. Let me see if there's actually anything here, because if there's not, then we'll skip over that. 188 says, at 10:11 a.m. PST on August 8th, Nathan and Sloane reached an agreement whereby neither would communicate directly with a reporter prior to informing the other. Nathan states, I am not doing one thing without speaking to you, to which Sloane responded, me either. Okay. For the foregoing reasons, the court should dismiss the civil extortion claims. 3, the amended complaint fails to state a claim for defamation. The Wayfarer party's defamation claim fails on multiple grounds. As a threshold issue, the amended complaint does not and cannot allege that Ms. Sloane made a single statement concerning 6 of the 7 Wayfarer parties. Okay. And I want to read this footnote right here really quick because it was right at the end of that sentence we just read. It says, Ms. Sloane also cannot be held liable for anything another person did, as California law requires a direct use of force or fear against the plaintiffs. Okay. Further, all 3 statements that the whole cast doesn't like Justin, the whole cast hates him, and Blake was sexually assaulted, cannot give rise to a defamation claim because they are 1, an actionable opinion. Well, I don't know if saying Blake was sexually assaulted is an actionable opinion. Well, it's certainly an opinion if it's not based on facts, but okay. Or in the alternative, substantially true. 2, not alleged to have been made with actual malice. And 3, not alleged to have given rise to special damages. The statement that Blake was sexually assaulted cannot give rise to a defamation claim for the additional reasons that this statement is not attributable to Ms. Sloane, and the circumstances of this statement are not alleged with the requisite specificity. A, Ms. Sloane's alleged statements do not concern 6 of the 7 Wayfarer parties. As a threshold matter, the Wayfarer Parties defamation claim must be dismissed to the extent it is asserted by Wayfarer Studios LLC, Heath, It Ends With Us Movie LLC, Nathan, Abel, and Sarowitz. It is axiomatic that to state a claim for defamation, the allegedly defamatory statement must be of and concerning the defamation plaintiff. Okay. Whether a plaintiff has adequately alleged that the defamatory statements are of and concerning him may be properly considered on a Rule 12b6 motion. Here, the Wayfarer Parties do not even attempt to allege a single statement by Ms. Sloane that is of and concerning 6 of the 7 Wayfarer Parties, and instead allege that Ms. Sloane made a handful of statements concerning only Baldoni. Accordingly, the Wayfarer Parties defamation claim must be dismissed to the extent it is asserted by anyone other than Baldoni. Okay. B, Ms. Sloane's alleged statements are an actionable opinion, or, in the alternative, are substantially true. Okay. We have 1, Ms. Sloane's alleged statements are an actual opinion. The Wayfarer Parties defamation claim also fails because Ms. Sloane's statement reflects an actual opinion. Only factual statements are actionable as defamation, and that's Chow v. Lewis. Defendants cannot be liable for simply expressing their opinion, no matter how unreasonable, extreme, or erroneous these opinions might be. Somewhere in California, Kanye's breathing a sigh of relief. All right. To determine whether a statement is one of actionable fact or inactionable opinion, courts consider 1, whether the challenged statements have a precise and readily understood meaning, 2, whether the statements are susceptible of being proven false, and 3, whether the context signals to the reader that the statements are more likely to be expressions of opinion rather than a fact. This inquiry is a question of law. Okay. Ms. Sloane's alleged statement that the whole cast doesn't like Justin and the whole cast hates him are clearly statements of opinion. Because these hyperbolic personal sentiments are not susceptible to being proven true or false, well, aren't they? I mean, I don't know. They cannot be subject to a claim for defamation. I mean, I feel like it'd be pretty easy to prove that true or false, but okay. Hyperbolic, yeah, probably. Okay. The statement Blake was sexually assaulted likewise amounts to inactionable opinion, given the context in which it was made. As noted above, the amended complaint does not allege what specific words Ms. Sloane may have said to the reporter, what date the conversation occurred, or in what context the allegedly defamatory statement was made. To the extent the Wayfarer Parties rely entirely on the image capture reproduced at the end of paragraph 193, the phrase sexually assaulted appears to be the reporter's characterization of details included in Lively's administrative complaint and not any words. All right, let's roll back over to 193 for a sec. Okay. 193 said, following the release of Lively's administrative complaint on December 20th, the same Daily Mail reporter informed Nathan that Sloane had lied to portray Baldoni as the foe. Yet still, Sloane escalated the false narrative by telling the reporter that Blake was sexually assaulted, an unsubstantiated accusation that not even Lively had gone so far as to claim, designed to destroy Baldoni and his reputation. Okay. Helene, thank you for the membership. I appreciate you. All right. So let's, hang on. Let me see this really quick. The amended complaint does not allege what specific words Ms. Sloane may have said to the reporter, what date the conversation occurred, or in what context the allegedly defamatory statement was made. Again, that's just like entirely odd to me, given the like lack of evidence or lack of specific details given in all the, you know, claims made in Blake's amended complaint. But okay. To the extent the Wayfarer Parties rely entirely on the image captured reproduced at the end of paragraph 193, the phrase sexually assaulted appears to be the reporter's characterization of details included in Lively's administrative complaint, and not any words Ms. Sloane ever said. Even if Ms. Sloane did use those or similar words, however, where a statement does not appear to be based on any undisclosed facts, but rather offers the speaker's perception of the facts laid out in a public complaint, the statement amounts to inactionable opinion. Okay. Even assuming Ms. Sloane used that phrase outside of the context of discussing Lively's publicly available administrative complaint and was not merely summarizing what she read or what others told her, the term sexual assault is insufficiently precise and means different things to different people. I mean, it's all, you know, if nothing happened, though, that's not sexual assault. You can mean different things to different people, but if it was completely fabricated out of nowhere, it doesn't really matter. All right. I mean, I can't, like I said, this is just my opinion. I'm not a judge. I'm not a lawyer. So I'm just speaking from a layperson, you know, public opinion standpoint. Okay. Courts have been hesitant to apply one definition of a word when there's a colloquial meaning, even if there is also a specific legal or political definition. Finding the word terrorist to be a statement of opinion, even when uttered by Attorney General during a press conference, because the court is not persuaded that defendant intended to use a specific legal definition and therefore is not convinced that the language at issue has a precise meaning that is readily understood. Okay. Because the text between Nathan and the reporter do not discuss any specific conduct by Baldoni or refer to any specific definition of the phrase sexual assault as used by the reporter, the phrase has no precise meaning that is readily understood. In a similar case, Barber v. Primo, a New York Supreme Court held that a statement that the plaintiff assaulted many people was an actionable opinion because there is no precise, readily understood meaning of what the speaker may have meant by the use of the term, and it appears on its face to be a hyperbolic phrase, and thus not defamatory. I mean, that's a pretty awful thing to accuse someone of, so you better be sure that you're getting your words right and that they actually did it. I don't know. Again, just my opinion. Courts have recognized that words like predators and criminals are vague, imprecise statements of hyperbole considered non-actionable opinion. In the alternative, Ms. Sloane's alleged statements are substantially true. In the alternative, to the extent the court finds that any of Ms. Sloane's alleged statements are statements of fact, rather than statements of opinion, the Wayfarer Parties' defamation claim still fails because those facts are substantially true, which is all that the law requires. A statement is substantially true when it has the same gist or sting as the truth, or when, even though technically false, it conveyed the same effect as the literal truth. Okay. Here, the Wayfarer Parties do not deny the truth of Miss Sloane's alleged statements that the whole cast doesn't like Justin and the whole cast hates him. Quite opposite, the Wayfarer Parties specifically alleged the cast sided with Miss Lively, ousted, shunned, and iced out Baldoni, and even refused to attend the premiere if Baldoni was present. Nor do the Wayfarer Parties meaningfully deny the truth of the underlying facts for the alleged statement that Blake was sexually assaulted. For instance, Miss Lively alleges that Baldoni engaged in sexual contact without her consent, including by biting and sucking on her lower lip during a scene in which he improvised numerous kisses on each take. The Wayfarer Parties do not expressly deny this conduct and merely argue that Baldoni did not need Miss Lively's permission to improvise because he was purportedly in character and his behavior was apparently acceptable on the show Jane the Virgin. But whether Baldoni believes sexual contact without permission is appropriate in the workplace has no bearing on whether Miss Lively consented to his unscripted advances, which she did not. As noted above, it is implausible that the speaker, whether Miss Sloane or the reporter, intended to convey a specific or legal meaning for the phrase sexual assault. But if he or she did, Baldoni's unwanted sexual contacts likely fall within New York court's definition of sexual assault, such that the characterization of Lively's allegation is substantially true. Therefore, the Wayfarer Party's defamation claim must be dismissed because all of Ms. Sloane's alleged statements are an actionable opinion or statements of fact that are substantially true. Anna Fan says, is Brian Friedman going to the attorney that's going to respond to this? I would think so, but I'm not positive. Okay. The alleged statements concerning sexual assault are insufficiently specific. The Wayfarer Party's claim for defamation, to the extent based on paragraph 193's allegations concerning sexual assault, should be dismissed for the additional reason that it is inadequately pleaded. Paragraph 193 of the amended complaint alleges that Sloane escalated the false narrative by telling the reporter that Blake was sexually assaulted. As between Miss Sloane and the reporter, however, there was no image capture or representation as to what specific and allegedly defamatory words Miss Sloane said or when. Instead, the amended complaint merely reproduces an image of an undated conversation between that reporter and Nathan that includes the words, "And now she's saying that Blake was sexually assaulted." The image of that reporter's text conversation with Nathan, taken sometime after December 20th, embeds an image of his August 8th conversation with Miss Sloane, and then describes the fact that Miss Sloane did not mention any allegations of sexual assault during their August 2024 conversation. To state a claim for defamation, purportedly defamatory statements must be identified with specificity. Specifically, a defamation claim must identify the purported communication, as well as who made the communication, when it was made, and to whom it was communicated. Because it is entirely unclear whether the reporter is purporting to quote Miss Sloane, or if he is paraphrasing or offering his own interpretation of different words that she used, or if the she to whom the reporter is referring is Miss Sloane at all, the Wayfarer parties failed to allege with particularity the alleged falsehood uttered. D. The Wayfarer parties failed to allege actual malice. The defamation claim also fails because Baldoni is a public figure who must plausibly allege that Miss Sloane made the statements with actual malice, and the Wayfarer parties failed to do so for any statement. Individuals who have assumed roles of a special prominence in the affairs of society and who have invited attention and comment are generally considered public figures. As he admits in the amended complaint, Baldoni was the co-star and director of It Ends With Us, which was one of the year's biggest movies. He is the co-founder of Wayfarer and has produced and directed multiple films that were meant to have a positive impact on the world. He played the lead's love interest in television's Jane the Virgin for 5 years. He has a podcast and has written multiple books, and the list goes on. These allegations are more than sufficient to plead Baldoni into public figure status. Baldoni is therefore required to plead actual malice to state a claim for defamation. That is, Baldoni must allege that Miss Sloane made her alleged statements with knowledge of their falsity or reckless disregard for their truth. The actual malice standard focuses on whether the speaker entertains subjective doubts about the truth of the publication. The court may resolve the issue of actual malice as a matter of law at the pleading stage. The Wayfarers parties failed to meet the high bar to allege actual malice here. The amended complaint is devoid of any factual allegations that Miss Sloane knew or should have known that her alleged statements were false. Miss Sloane was not a first-hand witness of any activities taking place on set, and, given Miss Sloane's long-standing relationship with Miss Lively, it is no surprise that she credited Miss Lively's story. The Wayfarer parties' conclusory allegation that the Lively parties knew the statements were false or had serious doubts about the truth of the statements is insufficient to plead that Miss Sloane's specific statements were made with malice, particularly considering that by the Wayfarer parties' own allegations, Miss Sloane's statements were substantially true. The amended complaint contains no allegations sufficient to allege that Miss Sloane subjectively harbored doubts as to the veracity of her statements, much less non-conclusory facts that support the proposition that Miss Sloane knew that she was reporting falsities. Like most individuals accused of sexual harassment, it is no surprise that Baldoni has made every effort to confuse the facts and blame the victim. But his predictable denials, however vehement, are insufficient to support a plausible claim of actual malice. The Wayfarer parties failed to allege special damages. The defamation claim also fails because the Wayfarer parties failed to allege special damages, that is, the loss of something having economic or pecuniary value. I hope I said that word right. I've actually never seen this word in my life. Which must flow directly from the injury to reputation caused by the defamation. Okay. These pleading requirements are strictly applied, as courts will dismiss defamation claims for failure to allege special damages with a requisite degree of specificity. Here, the Wayfarer parties make zero effort to plead special damages. Instead, they offer boilerplate allegations of harm to the Wayfarer parties' property, business, trade, profession, and/or occupation in an amount no less than $400 million. This is a textbook example of non-specific conclusory allegations that do not qualify plaintiff's harm with sufficient particularity to identify actual losses, and thus do not come close to meeting the New York standard for pleading special damages. The unsupported $400 million figure only confirms the deficiencies in the amended complaint. Such round figures, with no attempt at itemization, must be deemed to be a representation of general damages, and such figures are insufficient to plead special damages for a claim for defamation. The amended complaint, and this is number 4, the amended complaint fails to state a claim for false light. One sec, guys. Just had to fix something real quick here. Okay. Sorry, guys. I know everybody hates the dead silence, but I just had to do something really quick. All right. The Wayfarer Parties false light claim also fails. As a threshold matter, false light is not a cognizable claim under New York law. It must be dismissed on the grounds alone. Second, the false light claim is impermissibly duplicative of the defamation claim. The false light claim is based on the same alleged conduct and same alleged harms underlying the defamation claim, so it must be dismissed as duplicative. Third, the false light claim fails for all the same reasons that the defamation claim fails. Fourth, the false light claim fails because the Wayfarer Parties failed to allege that Ms. Sloane made any statements concerning them that would be highly offensive to a reasonable person, which is an essential element of that claim. Ms. Sloane made no statements concerning 6 of the 7 Wayfarer Parties, and her statements regarding Baldoni were made in good faith and are substantially true. Accordingly, the Wayfarer Parties failed to satisfy the highly offensive element. Well, what if I'm highly offended? Because like that troll said earlier, I'm not on the payroll for these streams. Right. Okay. Sorry. Ms. Sloane and Vision PR Incorporated are entitled to attorney's fees and costs. Upon dismissal of the amended complaint, the court should award fees and costs under New York's anti-SLAPP law. The statute applies to claims that, as here, are based upon any lawful conduct in furtherance of the exercise of the constitutional right of free speech in connection with an issue of public interest. The term public interest is broadly defined as any subject other than a purely private matter. And courts routinely conclude that statements regarding alleged sexual misconduct concern the public interest. Statements regarding prominent figures like Baldoni also concern the public interest. Okay. Under the anti-SLAPP law, fee-shifting awards are mandatory, not discretionary, where, as here, a lawsuit was commenced or continued without a substantial basis in fact and law. Because the Wayfarer Parties' claims all fail as a matter of law, Ms. Sloane and Vision PR Incorporated are entitled to recover the attorney's fees and costs that they incurred defending against the Wayfarer Parties' baseless claims. Okay. 6, the court should strike Exhibit A to the amended complaint. So this is where they want to strike the whole timeline of evidence. As previewed at the February 3rd, 2025 hearing, the court should strike Exhibit A to the amended complaint pursuant to Rule 12F. The Wayfarer Parties filed as an attachment to the amended complaint a 168-page single-spaced document that purports to be a timeline providing a summarized account of the sequence of key events. Exhibit A is an unsigned, one-sided, factual narrative containing selective excerpts of email and text messages with numerous redactions and alterations, including text, underlining, and other annotations. Well, I mean, at least they included some evidence, right? Okay. It should be stricken as it violates both the letter and spirit of the federal rules. Rule 8A requires that a pleading contain a short and plain statement of the claim showing that the pleader is entitled to relief. That principal function of this rule is to give the adverse party fair notice of the claim while avoiding placing an unjustified burden on the court and the party who must respond. Here we have footnote 11. It says Ms. Sloane and Vision PR Incorporated do not invoke the anti-SLAPP law's procedural protections and instead invoke only the fees provision, which is substantive. All right. Rule 12F authorizes courts to strike any redundant, immaterial, impertinent, or scandalous matter from any pleading. See Federal Rules of Civil Procedure 12F. When a complaint does not comply with the requirement that it be short and plain, the court has the power to strike any portions that are redundant or immaterial. A court may also strike information that is immaterial and irrelevant such that it has no real bearing on the case before it. As the court noted at a February 3rd hearing, Exhibit A is almost exactly the type of document the federal rules are designed to prevent. It violates Rule 8 because it is neither short nor plain. It does not provide fair notice of claims, and it places an unjustified burden on the court and the parties. Okay. The law of the circuit is pretty clear that you can't just attach a factual narrative because there's no mechanism for responding to the factual narrative that's attached. In addition, because the court cannot properly consider the information contained in Exhibit A and evaluating the incident motion, it is irrelevant and has no real bearing on the case before it. Conclusions. For the foregoing reason, Leslie, Sloane and Vision PR Incorporated respectfully request that the court dismiss the claims against them with prejudice, award them attorney's fees and costs under New York's anti-SLAPP law, and strike Exhibit A to the amended complaint. Victoria, thank you for the $3 super sticker. I appreciate you. And Kirsten, thank you for the 10. I think we all deserve compensation for this lawsuit. I was with an abusive narcissist for 3 years, and I feel more gaslit now. But I'm staying because I want to see them get their karma for doing this. Well, thank you, Kirsten, for sharing that with us and for the 10. I appreciate it. Guys, I work with emergent psych patients, and I've worked in various mental health settings for a long time. I grew up around it. My whole family's works in psych. And I gotta say, when I read these lawsuits, a lot of what I'm noticing is not the legal stuff because that's not my profession. And what I'm noticing is like a lot of the manipulated kind of attention grabby stuff that's meant to make you question things or see things one way or another. And so I might do another stream later or another video later explaining some of that if anyone's interested in that kind of thing. You guys let me know in the comments if that's the type of thing you would like to see. However, right now I still have to get back to my day job because I do have a 9-to-5 and I work multiple part-time jobs and I'm in school. So taking the time to do this is it's hard, but it's fun and I enjoy it and I appreciate everyone for being here. I really have enjoyed hearing from everybody and just being able to, I don't know, feel like I have a community of people. Since I do have to get back to work now, I'm going to send you over to my friend Dave Neal. Now, Dave Neal was the person who really got me into YouTube. So I made one YouTube video. Dave Neal saw it and he had me on his show and that's how I got into doing this. I never thought this was something that I could actually do. Like, I just thought, I'm just like a random person. So I never thought of speaking my mind this way to people and like kind of having anyone care what I had to say. So yeah. All right. I'm going to explain why we're so obsessed with this. Oh yeah, I can definitely do that. I can do that. And that applies to me too. Not that I'm obsessed, but why I'm interested and why it hits so hard emotionally. So, all right, everybody, please tell my friend Dave Neal that I sent you. Send him all the love. If you could, when you go over to Dave Neal's stream just now, put bacon emojis in his chat. Just flood the chat with bacon emojis and say they're from Lauren, and I would appreciate that. I'll see you all very soon. Back to work for me, though. Everybody enjoy your day, and I'll have some more for you later. Bye.